We're now considering the Home Rule petition to amend the HDC Act. And David, you have 4 minutes to describe your thoughts and rationale.
Very good. This citizens petition was brought forward in response to the Martins Lane situation of last year. The decision that was handed down by the court indicated that other legal language was speaking more loudly to them than the language contained in the Historic District Commission enabling legislation that allows us to oversee historic buildings and their settings. And so the intention behind the act was to strengthen the language to put back in place the kinds of protections that we had thought existed previously. It does it in two ways. Technically by expanding the definition of structure, which is what we've traditionally used, to include curb cuts and brick sidewalks and brick roadways. And then secondarily by adding a new category of protection called historic place. The petition has been modified since its publication here, and the intention is to allow the determination to be made at town meeting by the citizens of the town as to whether or not they wish to include someplace in historic place designation. So the motion creates really the framework and the shell which is available to the town to use should they elect to make that decision. It would only be after the town meeting voted to do so that HDC would have jurisdiction over any place that they designated. The act, or rather the proposed article, also has a couple of sections which give the HDC the legal means in which to implement and enforce the change. Rather than go into detail, let me say that in the last 24 hours in conversation with the leadership of the Nantucket Builders Association and some of the members of the Citizens for Sensible Preservation, there has come forward the idea that there are areas in which we have common agreement about the importance both of the HDC and of preservation to the island, and that we all think that there are some areas that are not adequately covered that should be. It's become clear that there is some confusion caused by the complexity of the legal language, which I'm happy to see addressed, and that some difference on the question of means rather than ends. And so we have agreed in common with the Nantucket Builders Association to bring on Monday night a motion to refer this to a work group that we will form with them and operate in conjunction with them. And that work group will invite other interested parties to come and speak to us, and we will work toward presenting a new motion in the spring, which we hope we can all agree on. And with that, let me take any questions.
Actually, let me have Matt make his presentation as chair of the Finance Committee on this article. Matt?
Thank you, Peter. In light of these recent developments, I will not make it. Presentation. Okay. I get the sabers out. But I will say this, the Finance Committee will be watching with great interest to see how this proceeds. And the Finance Committee also felt that this avenue, it would be beneficial to work out these issues. So we would, I think, it's safe to say that the committee supports what you're doing. So.
Thank you.
Okay, we have 3 written questions, and then I think we'll have ample time for questions from the audience. The first question, David, is how does the HDC plan to enforce the new regulations and powers that Article 11 would grant?
Article 11 doesn't change in any way the enforcement powers that the HDC has. It simply expands certain areas under our jurisdiction. So there's no change there.
The next question for you, David, is would you consider deleting sections 7 and 8 concerning separate legal counsel?
I think it's something that we can consider. I think it's there for good reason. There are I think there's some public misperception as to how often the HDC does find itself in disputes. We expect to do 1,600 applications this year. In the last 5 years, I think there have been 10 appeals of our decisions. That's about 1 in every 750. We don't initiate legal actions. The intention in seeking legal counsel is to help us defend when an action is brought against the decision of the HDC.
And the next question, which I think you may have answered in part already, is are there examples where the HDC has needed separate counsel? What are they? One of the oddities of the way the HDC and the town operate is that when appeals are made of HDC decisions, the appeal doesn't go directly to court. It goes to the Board of Selectmen, and they act as the first point of review. In any normal legal proceeding, you would have the person appealing, the person defending, each with their own counsel. And when you've got a group like the Board of Selectmen trying to make a decision, they also would have legal advice as to how they should decide it. Under the current structure, town council is put in the position of both advising the selectmen how to arrive at an impartial decision, and in the position of advising the HDC how to advocate its position. And there's a conflict there. One can certainly imagine that if one was appealing an HDC decision, one might feel that it was awkward having the legal counsel advocating the defense that you are appealing against, also advising the Board of Selectmen. And at the same time, there are times when the HDC has felt that it has not had the best possible representation before the selectmen and would have had the case presented and represented in a different way. So I think from both sides, there's good reason to separate the two, and it's the kind of thing that you would get in any normal legal proceeding. Next question, David, is have there been other historical district commissions in other towns that have been involved in such a conflict?
I'm not sure what such a conflict is. Perhaps we could get some clarification?
Does the person who posed that question want to give a verbal clarification? Yes, sir.
Yeah, it appears the...
Could you come up to the microphone and identify yourself? Thank you. We're ahead of schedule, so take your time.
It appears the question of the HDC having its legitimacy and then being overruled by the judiciary body, whichever one it was, has that happened in other parts of the state? Is there a precedent?
I would have to think that it does happen. I can't cite you specific examples. There are HDCs all over the country, and there are enough of them, and there would have to be enough circumstances that something of the kind existed. Yeah. I think it's worth saying that there are HDCs where appeals are taken straight to Superior Court, and that's another route. If that change were made, HDC appeals would go straight to court, and then town council could represent the HDC on behalf of the town without conflict.
Gino, are you paying attention? We have a question for you. Do you know when this will be rebroadcast?
Yes.
Pardon me?
It'll be on later today.
Later today.
Yeah, and it'll run in the loop. So
It'll run in the loop.
24 hours a day.
Okay, 24 hours a day.
Oh, Channel 99.
Channel 99. Remember that, Channel 99. All day, all night, more than you want to know. This question is, will the work group work in public as part of a public process?
It's not a governmental body. It's a group that's being convened by by two private groups. But it's our intention to invite participation from the public.
We're now able to take questions from the audience. Yes, sir. Would you come to the microphone and state your name?
Hello, my name is Richard Lofton, and I would just like to commend David and the other proponents of the article. I think referring to a work group is exactly the right approach, and I certainly look forward to progress on your part.
May I respond to that? I'd really like to commend the leadership of the Builders Association. We came at, I think, the same question from different ends, and we did not allow an initial disagreement, and I think to some extent misunderstanding, to prevent us from having a productive conversation. Both of us felt that there were things to be done for the good of the island, and the best way to do them was in a way that united rather than divided the island. And that sentiment was specifically expressed first by Steve Rothke. I want to give him credit for that, but I subscribe to that wholeheartedly. I think that we're both clear-eyed about the fact that when we sit down, we may not see everything the same way, and we may not be able to agree on everything, but we're looking to find a way to agree on as much as possible and unite around that.
Any further questions from the audience? If not, I'd like to thank you, David.
Thank you.
We're now going to have Andrew Vorse, who is going to walk us through the zoning and sewer map changes and the real estate acquisitions and conveyances.
So when there's an opportunity for a special town meeting, you know that this was generated by the financial issues you talked about earlier. We try to submit at least corrective articles or administrative articles to be included in this process. If we find that the articles generate any major controversy, we have recommended that they be put off to the annual. So hopefully you consider these minor articles as we do. Article 6, the first zoning article, deals with a map change. It involves two properties. It's basically correcting a line that we think was put in the wrong place when it was originally adopted. There's a detailed description in the planning board comment, which I think really explains the matter. Article 7 involved changes to commercial land out near the airport to industrial status. The property owner had originally requested this map change and then, I guess, changed his mind and asked for some further study. So there's recommendation of no action on Article 7. Article 8 is correcting some conflicts with the zoning enforcement officer. If you look at this article, there's two main parts of it. The first part changes it from a single person to any building official identified, and this is a reference to a state law. And what this means is that any building inspector can handle relatively minor zoning questions as appointed by the town manager. So what this is intended to do is to make sure that minor applications like sheds, like where minor zoning interpretation is required, doesn't hold up the whole process. And I think it's one thing that, as part of the new planning and land use services, we want to make sure there isn't unnecessary delays in processing permits. The second section just clarifies the zoning officer is appointed by the town manager, not by the Board of Selectmen. That's consistent with the charter, consistent with the job description as adopted in 2006. The two sewer articles, again, were submitted by citizens. They were not sponsored by the planning department or town administration. The first one, Article 9, would add two properties in Sconset. The second one, Article 10, would add 7 properties adjacent to Derrymore Road. When sewer extensions were originally considered, a checklist was developed and approved by the Board of Selectmen acting as the sewer commissioners. The Board of Selectmen, when they considered these at their last meeting, found that the sewer checklist was overly restrictive, considering the progress that we've made in reducing overall sewer, potential sewer connections in the future. As it stands right now, there's basically a net reduction of 700 units, and that's through zoning changes and through land acquisitions through the land bank. So at least for Article 10, where there's a possibility of 28 additional connections to the sewer, there's adequate capacity. And every one of these, since they're out of the needs area, would pay a premium to enter into the sewer. And the Board of Selectmen found that that was not taxing current or future capacity and would provide the sewer system with additional users and needed revenue. And the situation in Sconset under Article 9 provides for 2 homes. Again, they're both undersized. They both are strained to provide adequate septic capacity on their existing lots. And again, the selectmen found that adding 2 additional homes to that plant would not overtax the system.
Thank you, Andrew.
results.
Are there any questions from the audience on Articles 6 through 10? Yes. Catherine.
Andrew, I have a couple of questions. Is there any intent by the town to eliminate the zoning enforcement officer's position?
No.
Okay. And another question I had was, is there anybody in the Plus department who is certified by the Department of Public Safety? Because usually those people are the ones that do the building inspections, the wiring, electrical, or something like that. Is there anybody that's certified that is in charge now? Because I don't think that's your basic expertise, but...
Right. The zoning enforcement officer is not, does not have those qualifications, but the inspectors do. And under the law, inspectors can interpret and enforce the bylaw as well.
Mm-hmm.
So the inspectors do multiple things right now, and this would allow them to also do that same, basically to do that same duty. They could not only do their inspection, they could enforce the zoning at the same time. And they have that certification right now.
Okay, great. Thanks.
Other audience questions on Articles 6 through 10? Seeing none, I'm going to ask you, Andrew, to go on with the Articles 12 through 21, which are real estate acquisitions and conveyances.
Okay. Starting with Article 12. Article 12 and 13 are companion articles dealing with paper streets. We've had a number of these, which basically extend back to 2005. I do have a series of maps here if you'd like to take a look at any of these in particular detail. But this program has been operating and very successful, mainly in Surfside, where we've been doing quite a bit of closing out of these paper roads. The property is either returned to the residents, which they can incorporate into their yard space, or in some cases it's retained as open space. And there's a mixture of conveyances and retentions that are found in Article 13. Article 14 deals with a property that is in the Cisco neighborhood in the Moreland management area. It is currently owned by the county, and the proposal is to file a home rule petition, which is the requirement to transfer this property from the county to the town. The town has had a long-term policy to transfer all county land from county status to the town status, and the reason is the county is a subset of the state. If Nantucket County were ever eliminated, any remaining property would basically go to the state. And this is a 43-acre property that we think is important to retain local control over. For one reason or another, partly because of the way it's listed in town records, it says it's owned by the town, and that's why it was missed in basically a group that was transferred in the 1990s. Article 15 is a property on Dave Street. It's part of the old railroad bed. It was purchased in the 1920s, and the main sewer line was constructed underneath it. There is a redevelopment of this property. It's at the corner of Pleasant Street and Dave Street, which is going to radically improve that area. There's a new Cape Cod 5 bank. What we hope to do is create a park area at the corner, which will clean up asphalt and kind of this is the building where the old post office was, which will all be cleaned up. We will retain a sewer easement under the land and also a pedestrian easement. I know that the right-of-way committee is looking to incorporate scraps of the railroad area, for historical reference. So we have a very interesting proposal that we're looking at as well to move a building that used to be the Tom Nevers train station, owned by Mariah Mitchell, to this location. Overall, I think you'll see a great improvement of this corner. Article 16 is submitted by the water company, and this requests that property in Sconset where the standing tank used to be would be able to be sold as surplus. This particular property, as you know, the tank has been removed, and any proceeds from this sale would go towards the debt on building the new tower out in Sconset. Articles 17, 18, and 19 refer to property located along Sparks Avenue. Article 17 has a positive recommendation. What this would do would transfer a piece of this property, 15,636 square feet, to the Cemetery Commission, where the cemetery would be, the cemetery on Sparks Avenue would be expanded. Article 18 and 19, because there's basically been some controversy regarding the long-term use of this land, the recommendation is no action, so that this would come up at the annual town meeting. And finally, Articles 20 and 21 deal with a variety of, I will call them orphan properties that are located around the island. These properties have either been in tax title, where there are no owners to pay long outstanding taxes, or they're properties that are affected by erosion and have lost significant value. Article 20 would acquire them, and so basically clear the title. Altogether, they have a rough tax liability of about $700,000 to the town, and that continues to grow because there's penalties and interest on it. So Article 20 would close that off. Article 21 allows conveyance of that property. The majority of it would go to open space. Several of the properties would be available through the yard sale, which would somewhat offset that liability, but overall it won't cover it all. So again, that's the roster of the real estate articles. There are maps posted on the town website, and if you have any questions, please let me know.
Thank you, Andrew. Before we consider the written questions and then questions from the audience, I want to remind you that you want to stick around because there'll be refreshments afterwards. We're almost there, almost there. Andrew, one question that has come up is for the acquired paper roads. What public purposes do you envision for the acquired paper roads?
Some of them would actually be dedicated where they provide access to the coast and are actually on the coast. They would be dedicated to open space, or they would be retained and basically used as part of the overall long-term policy of a one big beach for the entire island. So quite a few of them would be, the public purpose would be for that. In some cases, we retain easements for utilities or for walking paths. That's been done in Surfside quite a bit. And for the parcels that we eventually determine have no public purpose, they're declared surplus, and then they basically are returned to the abutting owners. They become taxable property, and if they're not needed for a road or they're not needed for open space, that's really the best place for them.
Okay, and this is a question on Articles 18 and 19, and it was posed for Matt Mulcahy, but I don't believe he's here, so I'm going to ask you if you'd like to address it. It says, has there been, quote, or if there has been, quote, much review, end quote, for these articles, Articles 18 and 19, what more needs to be done which requires delay to annual town meeting?
I think in the beginning of this, I explained that articles that deserve a broader discussion about the future of resources where there has been controversy, we feel, and we agree with the selectmen, and I see Mr. Barnes has left, but I know he's a proponent as well, that those are best discussed at a broader forum at the annual town meeting. So while there's never been any controversy or different plan for the land identified in Article 17, there has been different ideas for what would happen with the land in 18 and 19.
Now we're ready to take any further questions from the audience on these articles. Randy?
Yes, Andrew, two questions. One, I think the cleanup of Dave and Pleasant would be terrific. Is this something that is budgeted, or is this something that would need to be, there would need to be a special fund to make that happen?
No, Randy, the funding for this is going to come from private sources. So most of the work is being paid for through the redevelopment of that property, and we anticipate that the land bank will be involved in partially in some of the other portions. So there's no public funding required.
And any idea of timing?
The article is being presented now because I believe they will be breaking ground shortly, and this is one of the reasons why it's here at the special, because in terms of coordination, it's going to be starting soon.
Okay. And the other one was Article 16, the selling of the property of the old water tower in Sankaty.
Yes.
Is that a building lot?
It is. The lot does meet the zoning requirement. It would be sold for residential purposes.
Okay.
Yep.
Thanks.
Other questions from the audience? Alan?
Thank you, Mr. Moderator. Alan Reinhardt, Chairman of the Cemetery Commission. Just on Articles 17 and 18, am I correct in understanding that those are simply permissive articles that allow the Board of Selectmen to begin the taking process, and that there is nothing in there that ties them to any specific disposition of the land? It just gives them alternatives. Isn't that correct?
It is, but there is a provision that acquiring it only for general municipal purposes is not allowed. So that's part of the issue, that the actual final determination would have to be identified.
But that is something that could be done at a later time once the taking process is begun.
The taking could occur at a later time, but the purpose has to be more defined.
I see. Got
Okay.
you.
Yep.
Thank you.
Any other questions? Ms. Stover?
Catherine Stover. Andrew, as you know, I've been a banner carrier for the cemeteries and the future of death care in Nantucket. And we've already gone 10 rounds with these pieces of property at town meeting when they were proposing a road from Pleasant Street? No, Sparks Avenue to the school. The thing that people really made clear was that they considered this to be cemetery property. No matter where the boundaries were, that was cemetery property. And I believe there are people buried on the second, not the first one that they've already approved to pass at town meeting, but the second piece. I believe there are bodies there and stones there. So clearly, I mean, it's like cutting off the dog's tail a little bit at a time by just, dragging this out. Why not, since the people already have made it clear that they don't want this touched for anything but cemetery, why don't we just go ahead and do it? Or would that be an argument on town meeting floor?
Well, it would, but I can answer your question. Number one is that there's permitting and other things that are required to extend the cemetery into this property. So if there are burials, they have not been done in accordance with law. When we reviewed this before, and this is statutes that have been on the books since the 1840s, you can't just simply expand land for a cemetery into adjoining land without this approval. So this is, until there's, and I know you have consultants on the case right now, but until it's actually determined that the cemetery can expand here, that's part of the reason to hold off.
Okay, and what has to happen before that would be?
You need permission from the Department of Health, or I guess it's Department of Environmental Protection now. There's wetlands here. There's a number of issues that have to be addressed that are present on at least 18 and 19, not on 17.
Okay.
Right?
Well, one of the reasons I think that there's such urgency for this is that there is CPC money now to expand and to pay for whatever is necessary to make these cemetery properties, a garden cemetery, a park, or whatever regarding the wetland issues. So if there is some way that you can think of that we could amend this article to limit that use and clear all those, problems with it,
Yep.
I think that would be awesome. People really do need the cemetery space. We have the money right now to plan it all out.
Okay. Am I correct in understanding that the study and the person that you've been retained is being paid for with CPC funds?
Yep.
And his work will be done between now and December?
This December?
Yeah, January?
I'd have to defer to the Cemetery Commission. I've only been on the outside of this,
Okay.
in the past, so.
I'm seeing Alan shake his head yes. So I think,
Okay.
depending on the outcome of that work, I think, in a way, that's sort of another reason why it should come up at the annual.
Okay.
Okay?
Further questions from the audience? If not, I want to thank you for attending, and for our television audience, I want to underscore the importance of your showing up at annual town meeting Monday at 6 p.m., because we must have a quorum to conduct the town's business. If we don't have enough people, it will all have been for naught or almost naught. Thank you again.